ethics, professional responsibilities, and general principles. The first thing that we are going to see under this is AICPA Code of Professional Conduct. We have been given the Code of Conduct by AICPA. In addition to that, a practicing accountant is bound by the code given by Securities and Exchange Corporation (SEC), Public Companies Accounting Overseas Board (PCAOB), Governmental Accountability Office (GAO), and Department of Labor (DOL). Introduction and Preface. The Code of Professional Conduct was not an additional format. Starting from December 2014, there is an electronic version available for the Code of Professional Conduct. It is an actual written document. In addition to this, there is a conceptual framework as well, which came from December 2015. Because it is electronic, it is easily searchable. You could update it easily. Instead of trying to insert something in a paper book, inserting something in the digital format was easy. And it is located on the AICPA website. The code itself has a Part 0, which is basically the preface of the code. The code is divided into 3 main parts. Part 1, which is applicable to members in public practice, MIPPs. A major part of your code of conduct is here. These are the members of the institute who perform audit functions. Part 2, which is for members in business, MIBs. Part 3, which is for all other members, OMs. If a member is into multiple roles, suppose he is an auditor for some other businesses, he may have businesses. In that case, the rules which are the strictest will apply to him. These principles and rules are supported by interpretations in different journals and all by the institute itself. Definitions, applications, standards by state CPA societies, SEC, PCAOB, GAO, and Department of Labor. In addition to the Code of Conduct, there are all these literatures which are available, and the rules given here also are binding. A CPA has to conduct himself as per the Code of Professional Conduct. As per the Professional Conduct, there are 6 principles. 6 principles of professional conduct. Number 1. Responsibility principle. A member, whenever he is responsible for some work, he should exercise professional and moral judgment. He has to improve the art of accounting. If an auditor assigns an incorrect financial statement, the public loses trust in your profession. So it is your responsibility to maintain the public's confidence, and it is your responsibility to carry out the profession's special responsibility for self-governance. You have to know what you are doing is right and do it accordingly. Number 2. Public Interest Principle. It is your responsibility to maintain the public trust, to maintain the faith that the public has in the profession. The member should act in such a way that will serve the public interest, honor the public's trust, and demonstrate a commitment to professionalism. A professional institute, whether it is law or medicine or CPA or any other profession, it has a responsibility towards the public. Unprofessional behavior brings a bad name to the entire community. Number 3. Integrity Principle. Integrity means doing what is right, even if it is at the cost of your gain or benefit. A professional should perform his duties with the highest sense of integrity. You have to maintain the public's confidence. Number 4. Objectivity and independence. A member should maintain objectivity. Objectivity means being fair, impartial, being without any bias, no prejudice. You look at the facts and then accordingly you decide. You don't decide on the basis of your gut feeling or your bias to judgment or your prejudices. You don't let them influence your judgment. Independence means there should not be any conflict of interest while doing your work. A member in public practice (MIPP) should be independent in fact and appearance while providing attestation services. So just being independent is not enough. Everybody should be able to see that he is independent. Independence is required only for attest services. Integrity and objectivity is needed for all services. Whether you are doing audit, consulting, tax services, compilation, for everything you need integrity and objectivity. Number 5. Due care principle. Whenever you are doing your work, you have to do it properly. Maintain care. You have to maintain your profession's technical and ethical standards. Technical standards mean, like say, if you are doing an accounting job, you should be doing it as per US GAAP. If you are doing auditing, you have to follow the auditing standards, etc. You have to continuously look at improving your competence, your quality of service, and you have to discharge all your responsibility to the best of your ability. That is called due care. Due care includes planning of your work and supervision of the assigned work. You need not be perfect. You are human, and you cannot be perfect. So the requirement is not that you have to be perfect. The requirement is you need to be following the standards and doing the work carefully, with due care, not being careless or reckless or not even bothering to follow your standards. Competence means continuous professional education. When you say improving competence, it means continuous learning. The learning can come from research, consultation with experts, etc. Number 6. Scope and nature of services. Whenever you determine the nature and scope of services that you provide to your client, you have to follow all the principles of your code of conduct. What should you do? A. You have to practice with firms which have good internal quality control procedures. B. Use your judgment to determine conflict of interest. C. Whether the scope of the work is consistent with your role as a professional. Those are your 6 principles of professional conduct. In Part 0, the preface contains about 50 definitions. One of those are: partner equivalent is somebody who is not a partner, but he has ultimate responsibility for the conduct of an attest engagement, or he has the authority to bind the firm to conduct an attest engagement. Member in public practice. Introduction and conceptual framework. These rules apply to CPAs who are in public practice. Public practice means audit, which includes professional services such as audit, tax, and consulting for a client by a member or member's firm. That's your Part 1, applies to these MIPPs. Part 1 also applies to government auditors, also who work within a government organization and audit governmental department, and not necessarily only for public limited companies. There are 3 steps to applying conceptual framework on MIPPs. Number 1. Identify the threats. Number 2. Evaluate the significance of the threats, whether they are up to acceptable level or not. Number 3. Identify and apply safeguards to protect from the impact of the threats. The conceptual framework applies when the code of conduct is silent and it does not cover a specific issue. If the code of conduct covers the issue, you are going to follow that. But if the code of conduct does not specifically cover the issue, then the conceptual framework applies. There are 7 kinds of threats which have been identified in the Code of Conduct Part 1. 7 types of threats. Number 1. Adverse interest threats. This means that you want and the client wants is opposite or adverse to each other. This can happen when the client decides to sue you or threatens to sue you. You win, the client loses. Client wins, you lose. Suppose the party made a payment to the client. They are not able to recover from the client. So they decide to come to you. So you are the third party to recover from the client, and he has come to you. So again, you have an adverse effect. So that is an adverse interest threat. Number 2. Advocacy threats. An advocate is a person who will publicly support you, or he will support what you are saying. He will recommend you. That is advocacy. Suppose you are acting as an investment advisor, or an underwriter, or a promoter, or an agent for the client. That means you have become an advocate of the client. Once you became the advocate of the client, you lose objectivity. So that is a threat. Advocacy threatens your independence and objectivity. So when the member provides forensic accounting services to the client for a lawsuit with a third party, so now you are not an accountant or an MIPP anymore. You have become an advocate for the client. So when you become an advocate, you lose objectivity and independence. Number 3. Familiarity threat. This is a threat where somebody who is close to you is working for the client. Suppose you are the auditor and your spouse is the CFO or somebody who is a partner in the firm. He has taken up a key position at the client's place. These are again familiarity threats. Number 4. Management participation threat. When the member takes on the role of a client management, instead of being just a member who is advising or a consultant, you become the part of the client's management. That is a threat. You are losing objectivity. You are losing independence. There are all kinds of issues with participating in the management. Number 5. Self-interest threats. This means a member has self-interest in the client. He has some kind of financial interest in the client. For example, I own shares of a client, and then I submit a report on the client. On the basis of that report, the stock prices will change. So I have a self-interest. If the stock prices increase, I make money. I will probably not give a negative report at that point of time. So if the member has financial interest in a client, that may be affected by the outcome of professional service engagement. Or let's say 70% of my revenue comes from this client. I wouldn't say anything which the client won't like. That's a self-interest threat. Number 6. Self-review threats. Self-review means when you audit or review your own work. Suppose I am the accountant as well as the auditor. So I prepare the financial statements and I also audit them. This doesn't make any sense. Some other member or my own firm prepares the statement and I review the statement. That also does not make sense. So self-review takes away the independence of the member. Number 7. Undue influence threats. Undue influence is where the client has a way to influence your report or your judgment. Suppose the client threatens or one of the shareholders of the client is threatening that if you don't do this, we will terminate you as the auditor. That is an undue influence, where the client or his major shareholder tend to or try to influence your decision. These are your 7 types of threats which a MIPP could face. How do you bring down the threats to an acceptable level? There are 3 kinds of safeguards to deal with such threats. Number 1. First is one which is created by your profession. That is your institute, legislation, which is by law or by regulation, which could be SEC and all. Number 2. Second are safeguards, which are implemented by the client. The client himself will put certain safeguards in place so that the threats do not impact him. Number 3. Third are the ones which are implemented by the member firm. If the member firm desires to maintain a good quality control, then they will also have certain safeguards in place which will reduce the threat level or bring down the threat to an acceptable level. Safeguards. Number 1. Profession, legislation, and regulation. Some of the things which the profession has done is: it wants you to go for continuous professional education so that you can maintain your competence. So this will give you education and training. Your code of conduct, which is professional standards and threat of discipline. If you do not follow your code of conduct, the institute disciplines you through fines, penalties, or you may even lose your membership. Then you have external reviews of the firm's quality control system. Whatever work you do is reviewed by other firms. You have legislation which establishes different prohibitions and requirements for a firm. Then you have requirements for experience and competency for a license. If you are a MIPP, you need a license, and for that, you have the requirement of experience and competency. You have professional resources, such as hotlines for consultation on ethical issues. So in your work, you come across an ethical issue and you want somebody's opinion. Some party which is not directly involved and you want that opinion. You can call up this hotline for consultation. These are the different things which have been put in place by your profession, by the rules, by the regulation, which act as a check or safeguard on the threats. Number 2. Implemented by the client. Second set of safeguards are implemented by the client. The client also hires good people with skill, knowledge, experience, so that he can make decisions regarding the delivery of services by the member. So he can judge whether the work being done is of proper quality or not. The client's committed to ethical behavior, proper financial reporting, his tone at the top. If it's a client which values all that, then that itself acts as a safeguard. You got a good ethical client. There is not a bigger safeguard than that. The client has all the policies and procedures in place so that it achieves fair financial reporting and compliance reporting. All the financial statements are prepared fairly, accurately following the law. To sum up, client personnel, skills, knowledge, experience. Tone at the top. Policies and procedures for fair financial reporting and for ethical conduct. Audit Committee. This includes your independent board of directors whose job is to oversee the audit. Those are some of the safeguards which are implemented by the client. Number 3. Implemented by the firm. The firm has to set an example, stress on a rule that you have to act in public interest. All the members of the firm have to comply with the rules and regulations. They have to be acting in public interest. The firm should have engagement quality control procedures, and they should be implementing and monitoring those procedures. Somebody from the senior management should be assigned to look at the quality control system. This is not a role for junior level people. There should be a disciplinary mechanism. If somebody is found to be not complying with the rules and regulations, there should be a way to discipline him. Some kind of penalty or punishment should be there. The senior personnel on the team should be rotated. It is a rule now. Every 5 years, the senior partner has to be rotated on an audit. Whatever the rules are regarding independence and not doing certain non-audit services for your audit client, you have to make sure that you do not provide those services. These are the different safeguards which are implemented by the firm.